first, right? That's not, that's a very individualized process. So we spent the time to go through with them and identify and work with them closely, and to make sure, again, that it was consistently applied, not, not too much, not, kind of that we're, and that's why we met with every single agency, because we could talk about what it looked like, broadly across the agencies.
Very good. So reconcile for me the fact that we have heard testimony that folks were hired and replaced on the same day without a job posting. How does that reconcile with the org charts that you sent out? And I know maybe you didn't have anything to do with that, but that was apparently a director order from someplace. Was that followed or not?
I can tell you that this process, I assume that you're referring to the DAS layoff that happened in September of 2011. Again, I can't speak to the details because I wasn't employed at the time, but what I can tell you what I can tell you is that the revised definition of confidential employee and the movement of those folks to merit exemption did not happen until over a year after that layoff took place. So I just want to make the distinction that the process that we're talking about related to confidential employee happened well after that particular layoff.
So that under the old rules, and that might have been a violation of that old rule, where it was supposed to be posted, and these folks were supposed to be merit, and they were supposed to be contracted.
Again, I can't speak to the specifics, but what I can tell you is that there was a review of the positions at that time, and the positions were deemed to be, as a result of the reorganization, I feel like I don't want to speculate, but as a result of the reorganization, the positions were deemed to be non-merit.
Sure.
And so, yeah,
Very good. Thank you, Madam Chair.
Thank you, Madam Chair. Michelle, I'd like to follow along with some other questions for you. Yesterday, when we heard testimony, I believe it was Lon, somebody that was at the committee meeting yesterday, correct me if I'm wrong. I believe it was Lon that I asked about I think the way I phrased the question was, I had previously expressed concern about some of the people that had been terminated or laid off, and their personnel files were sealed, and they were on, their personnel files were coded as to do not hire. And my question was about what types of things they had done that resulted in them having this code on their personnel files. As should be expected, there was, not able to answer at this time. Perhaps as a personnel person, you could be really precise in how I phrased it. If I were a state employee, a merit employee, could you give me some examples of things that I should not do in order to have my personnel file flagged as do not rehire?
Sure, I can provide some information related to that. First, can I refer you to another one of the handouts that I provided that I think will be good context? Sorry, I should have probably put headers on these, I apologize. But it's the one that's labeled disqualification or removal of applicants. It's the one that has probably the most information on it of all of the four I provided.
Is it an email to?
It's not an email, it's just a Word document. I apologize.
You all and committee members got a copy. And then we'll make sure that LSA gets a copy so that we've got it on the oversight website for people who would like a chance to review it. Sorry, LSA.
Everybody at the table should have that one, though. Everybody at the table should have this one.
Okay, I'm just saying for the people that are interested in following the oversight hearing. Okay.
So this is actually, the top portion of this is the rule that's related specifically to the disqualification process that you were referring to. So I can do two things. I can walk you through kind of the criteria in which we would review and determine based on this criteria if a terminating employee would be indeed coded as excluded within our system. And then I can also provide some examples too, so to make it a little more real life for you. So when you take a look at this rule here, there's a list of A through K of reasons in which at the time of separation an employee may be coded as excluded. I will point out probably letter G is probably frankly one of the most common. And that's essentially saying that someone is involuntarily terminated. So if there's a termination for reasons of behavior or performance that result in the termination or separation for an employee from state government, that would or may result in the future exclusion of that individual from at the time they become an applicant.
I guess I was as really intended and apparently did not phrase my question properly. So I'll try again if it's all right. Can you give me some specific
Yes.
examples of exactly what, because my real fear is that we have had employees at the Veterans Home or at University Hospital that was found to perhaps be abusing an elderly, and that they could go back out into the private sector and with their fire clothes, no one would ever know, and people that are basically defenseless would be open.
Sure. I was providing the rule to give kind of the broad context, but I certainly did come prepared with a few examples to share. These would be examples that have led to the termination of employees from state government, and because of that, so again, going back to letter G, they were then also marked in exclusion status, which essentially means that at the time that they become an applicant, if they choose to become an applicant, the state of Iowa again, their individual record would be reviewed, and because of the terms of their separation, they may not be allowed to, or would not be allowed to be passed on as on that list of eligibles onto the hiring authority that I talked about earlier. So I'll just go through a quick list here of, again, some particular examples, some specific examples. A failure to initiate CPR on a resident, abuse of sick leave, the deliberate falsification of records, lying during an investigation, urinating on an inmate's food, failure to maintain appropriate boundaries with an inmate, threatening to resolve conflict with coworkers through the use of a gun, dependent or child abuse within our system, theft of property or cash, sexual harassment, providing contraband or favors to inmates, and then the last one that I came prepared to share was viewing or disseminating pornographic material while either at work during work time and or through state of Iowa provided equipment.
Stunning. Inappropriate boundaries with inmates, are we to understand that probably have sexual connotations?
Unfortunately, there's probably not just one in particular, but certainly, yes, there could be some relationship issues.
Okay, and contraband or favors, are we talking Tootsie Roll Pops or something?
That's a fairly broad category that I came prepared with, and it could mean a whole lot of things, frankly.
Could you be more specific as to what those favors might have been?
Again, this is that one in particular. I came with kind of some very specific categories, and I came with some broader categories that kind of we've had a number of violations of, frankly, and that one has, I would say, we have had a number of violations that would fall in that category that could be bringing, items or weapons or things or that perhaps are prohibited.
Well, I wouldn't be doing my due diligence if I did not ask about the urination question. So, can you repeat for me exactly what you said? Did you say urination into an inmate?
What I stated was urination on an inmate's food. And again, I want to be clear my intent here was just to provide examples of termination reasons that would have then potentially, and as with any employer, hiring and termination decisions happen on a regular basis. That's part of being an employer. And so I'm not trying I just wanted to give some context. That was the purpose of the examples.
Okay, so we have to assume then that would have been someone who was an employee within the prison system, not necessarily a guard, perhaps a kitchen worker.
So,
I mean, that's what, and that's the very thing I was talking about with the elder abuse thing. This person's file is sealed, goes on to other employment. It's certainly, I mean, he has experience in the food service industry. Wow. We as legislators have a responsibility to protect the public. Thank you very much.
Thank you, Senator Griner. Michelle, let's be clear on this. If there is elder abuse or child abuse going on in state government, explain the role of the state agency in recording those abuses so that they would get put on the abuse list. I mean, if he did not report those things, we would be liable for not getting their names on a list for doing something illegal. Please verify and explain this. We all are clear the process.
yeah, to be clear, we as DAS get involved with employee issues and situations happen very continually. Again, we're a very large employer. It's part of what we do. My staff becomes involved in investigations with departments when they get to be at a fairly high level in nature. Departments are doing their own investigations and handling employee issues on a regular basis and don't need our involvement. When they get to be a little higher level or more egregious in nature, we do get involved, and we work very specifically, Senator, with those. So, with DHS, for example, we would work very specifically with them to follow the appropriate procedures. They would actually be the ones responsible to make sure that the appropriate reporting happens and things like that. So I never in any way meant to say that wouldn't happen. That certainly would happen as a protocol, and everybody would follow the rules and regulations related to reporting that abuse. Absolutely.
Okay, Senator Reiner.
Would it not be possible, though, as a terminated employee was leaving, that a settlement of some type was negotiated And a component of that settlement could be the fact that they weren't reported.
I can't comment on that. I'm certainly not aware of anything that has happened like that, and I shouldn't.
But how many of those termination agreement sessions have you sat in on?
Is the question how many termination meetings have I sat
Yeah.
on?
Do you set in on all of them? So would you be aware if there were deals cut?
No, but I certainly want to be clear that I don't want to, there are reporting procedures, as Senator Peterson pointed out, related specifically to abuse and things like that, and I'm not aware of any times in which a settlement would be done that would be in violation of a rule. But no, to your point, no, I do not sit in on every one of these.
Thank you. Senator Greer, that would be illegal if that were occurring. Michelle, I want to follow up with some questions. Last week we were going to have you before the Government Oversight Committee and the Governor's Office informed us you weren't prepared. What did you need to do to get ready for today's meeting?
Senator Peterson, I will say I'm not sure if that was a miscommunication, but I was actually very prepared. So I apologize if there was a miscommunication along the line. I was prepared and ready to present.
They were very clear with me that you were unprepared, so that was them misunderstanding.
Perhaps there was a
Have you
miscommunication.
communicated with them about the oversight hearing?
Certainly, again, like I said before, DAS is in fairly close communication, and of course they were aware that I've been asked to testify, yes.
Okay,
They
and
were
did
aware
they
of that.
sit in on any preparation sessions with you, getting ready to come before the oversight committee?
Just to clarify, the governor's office?
Yes.
No, I did not do any preparation with the governor's office for my testimony.
Okay. Did you sit in on any preparation sessions with Director Carroll before he came to testify to the Government Oversight Committee?
I was not involved in any of the preparation sessions. To be clear, he did ask for, I had about a 5-minute meeting with him to talk specifically about the disqualification process.
Okay.
But that was the only thing I was involved in, and that was, again, a very brief and narrowly focused conversation.
Okay. Did you tell Director Carroll that there were no payments for silence?
No, I certainly was not asked that, nor did no.
Okay. Were you involved in any of the settlement agreements related to the reduction in force within DAS? I know the layoff occurred before you joined DAS, but the settlements then followed after
Yep.
you began.
That's true, and no, I was not involved in them.
You were not involved.
That's correct.
Did you ever talk to Ryan Lamb about any settlement agreement?
Not to my knowledge, no. Not that I recall.
And did you ever talk to him about any pay for silence?
No.
Okay. A lot of questions raised about this do not hire list. I still, we're still getting calls from people that are saying they have no clue why they're on the list. And yesterday, your good friend, Lonnie Anderson, said we could direct all those calls to you. And I'm sure you're excited about that.
Thank you, Ellen. Yeah.
Walk us through the process. You read in the register, an AP article, there's this list, you look, and your name is on it, and you have no clue.
Sure.
Tell me what you tell each one of these Iowans when they call. Do you have a reason for each person being on the list? And can you cite the reason? Can you cite the date and who put them on the list?
Sure. So as I referred to the list before, the rule was actually, the rule related to disqualification was put in place in 1987. So I believe that's 27-ish years. It's been, generally the rule has been the same since that time. We did make a slight revision to the rule in 2012. Essentially, I think there's been a little bit of confusion about the rule, but the rule as written doesn't actually become active until at the time that a former employee becomes an applicant. At the time they become an applicant is when the exclusion process actually occurs. So I just wanted to make sure, and there are appeal rights upon each time an individual becomes an applicant. They would receive notification of their exclusion, along with, of course, contact information so they could call and